Invite you all to another interesting webinar. I'm Dr. Ravi Kohli, the current president of AAPI, and we have a distinguished panel here discussing about the physician medical legal workshop, compliance with Stark law, anti-kickback statutes, professionalism, liability cases, etc. Our panel includes attorney Clay Countryman, partner at Rizal, Shashay and Wilson LLP, Baton Rouge, Louisiana. We're looking forward to hear your Southern accent, listening to you. And Adrian Dresevich, attorney and founding partner of Health Law Partners, PC from Framingham Hills, Michigan. And attorney Robert Dindoffer, a partner at Health Law Partners, Farmington Hills, Michigan. And our panel also includes our esteemed advisors of AAPI, Dr. Vemuri Murthigaru, and our CME chair, Dr. Srini Gangasani. So without much further ado, let's get going and let's get started with our important CME panel discussion. Thank you.
Yeah, thank you, Ravi. Good morning, everyone. Yeah, as Ravi said, my name is Srini Gangasani. I'm from Atlanta. I'm a CME chair for 22-23. So this is our 7th CME in the part of this year. So we had a great representation by great speakers so far, and every time we had an excellent participation from our AAPI members. So the few the rules for the meeting today. So there is a question and answer button on the bottom. If you have a questions, please put it in there instead of doing the chat box, so that will be easier for the panelists to look at. So sometimes we get lost in the chat when we're talking about it. So please put your questions and answers in the Q&A button on your screen. The next is, I think there was some question about some of the CME certificates not being done. I think we've just mailed all the GHS CME certificates so far. I think most people would have gotten it, GHS people, and then the last CME. So if you didn't get it, please contact our AAPI office or contact me at sriniji@gmail.com so that we can take care of that CME. We have a few more new CMEs coming up in the next month or so, with the nephrology CME and the lifestyle CME in April and May. And there's another one probably in the end of May with from Dr. Nerabatla. So I would like to thank actually all the speakers today. I think we've been talking about this webinar since September. I think I remember first email from Vemuri Murthigaru from September 15th. I think we've been going back and forth to find the correct speakers and get the date for it. So finally, time has come. I think we want to hear what you guys have to say. I think every doctor, I think we need to know a lot of legal aspects. I think last week, last session, we had a board directors from the medical boards educated us with so many of the problems the physicians face. Now we're going to the other side to see what the legal aspects are. As a physician, we need to know so that we can learn from somebody else's experiences. So without further ado, I would like to introduce our moderator and my mentor for CME. I think I learned a lot from Dr. Murthy over the last few years, but I think this year he's advisor to the CME committee, and he has done a great job educating and putting together the CME for the whole year, just planning for me, helping me with the CME for this year. So Dr. Murthy is the moderator for today's program. He's been a patron member of AAPI for more than 2 decades and has served several organizations, including chairman of the CME committee a few years ago, and had done a wonderful job with the great speakers. And an U.S. resuscitation training and research expert. He's an adjunct faculty in the Department of Emergency Medicine at the University of Illinois College of Medicine, Chicago. He's a visiting professor at various medical institutions in India, including the AIMS Mangalagiri, and where he just came back from with excellent educational sessions there. Thank you, Dr. Murthy, for wonderful experience with CME and advising me for CME. Without further ado, please take over. Thank you very much.
Yeah, thank you, Dr. Gangasani. Good morning. It's my pleasure to moderate today's medical legal workshop of AAPI. As U.S. physicians, we all recognize the importance of updating our legal knowledge from time to time to guide our respective medical practices. Today's workshop is designed to capture the essence of these guidelines with the most recent updates. I thank the AAPI president and members of the CME committee, especially the chair of the CME committee, for offering today's highly sought after program to the membership. We have a speaker faculty of nationally renowned legal experts who will provide us the basic and updated information and advices on various areas of healthcare law, including compliance and healthcare fraud. Following the three speaker presentations, we will have a question and answer session for about half an hour. Today's program is eligible for 1.5 hours of Category 1 AMA ERA CME credit. Our first distinguished speaker, who also previously contributed to AAPI's medical legal workshops, is Mr. Clay J. Countryman. He is a partner of Brazil, Saxe and Wilson LLP in New Orleans and chair of the American Bar Association Health Law Section. In addition, he is a nationally recognized speaker and author on healthcare legal topics. Mr. Countryman represents clients in all areas of the healthcare industry with a primary focus on healthcare business transactions, including mergers and acquisitions, joint ventures, private equity investments, and other business transactions. In addition, he has extensive experience in advising healthcare clients on the starting, anti-kickback statute, government investigations, and other healthcare fraud and compliance matters. Mr. Countryman has been legal counsel to several different types of healthcare providers and provider organizations, ranging from national and regional health systems, hospitals, and ambulatory surgery centers to specialty physician groups and physician clinics. Mr. Countryman has given hundreds of presentations and extensively published healthcare law articles. He is the recipient of several prestigious honors and recognitions for his outstanding contributions to the healthcare sector of the ABA. On a personal note, I am proud to have worked with Clay at some of the national medical legal conferences. AAPI welcomes Mr. Clay J. Countryman.
Dr. Murthy. Good morning, everyone. We are honored and excited to give the webinar this morning. I have two esteemed speakers with me, and I appreciate the introduction from Dr. Murthy. I've known him for several years now, and I appreciate our relationship, friendship, especially with the Chicago Medical Society and with AAPI and with Dr. Murthy. So that associated with. So this morning, our presentation deals with we're going to talk about the federal fraud and abuse statutes, the SARC law, the federal anti-kickback statute, and our focus with both those bodies of law and federal statutes and the regulations is to give an overview and at the same time drill down how that applies to you as a physician and a physician practice, and in that what you need to know category. And we're also Bob Denhofer, who's a partner in with the Health Law Partners in Detroit. He's also going to talk about malpractice issues from a physician's perspective, some recommendations, as opposed to say, and walk through that also. Or at the middle of our presentation, we're also
sorry to interrupt, Clay. I think there is the voice is kind of not very clear. I think, can you put the speaker a little bit, come to closer? I think as an intermittent, we're losing you. Thank you.
Okay, sorry about that. How's this? Is this better?
It's better.
Right. So with our presentation, I think our target is to speak for about an hour, maybe a little over an hour, and leave time for questions at the end. But we're also going to monitor, as Dr. Murthy said, the Q&A box. If you post questions, we'll try and work those into our presentation. So if we go to the next slide. Go ahead and skip my slide. that's my best picture. I'm going to use it for several years. Anyhow, we'll go on to the next slide, and we'll skip 2 slides because the next 2 slides are our bio. The next slide, that's Adrian. Not sure if that's her true picture. And then go ahead and skip the disclosure slide. This is what we call the roadmap for our presentation. The focus, as I said, the Stark Law, the federal anti-kickback statutes, new practice considerations, and common recommendations in professional liability or malpractice cases. On to the next slide. Adrian's going to take the lead on the Stark Law, and then Bob and I will chime in and correct her when she adds things. Go ahead, Adrian.
Okay, thank you, and welcome. Thank you, everyone, for attending today. And my name is Adrian Dresovich, and I spend a lot of my time guiding physicians and other healthcare clients regarding the Stark Law. And we could probably spend days and days talking about Stark, and we won't do that to you. We're going to try to distill it down to what is important for you and your practices, whether you are employed by a health system, whether that you practice independently with your own physician practice. Stark is going to apply to many things that you potentially do. So it's important that you understand the Stark Law and what it prohibits. And so this first slide really just takes us through the basic prohibition. And what it says is, as a physician, what Stark prohibits is a physician from referring Medicare patients to an entity for what's called designated health services, for which Medicare will pay if that physician or the physician's immediate family member has a financial relationship with that entity. And the big kicker here is an unless an exception applies, because Stark will be triggered by a lot of common arrangements. So just think, as a physician, you refer to the hospital. Maybe you're referring to a lab for lab tests, or maybe you're ordering DME or home health services. All of those are referrals to a designated health service. So if you as a physician, if you have a financial relationship with that entity, so in a real common example, a physician, maybe you're a medical director with a hospital and you also refer to the hospital. So that medical director agreement needs to meet a Stark exception. So that's a pretty common example. See if we can go to the next slide. And what happens if the Stark Law is triggered and you don't meet an exception? Well, there's pretty draconian penalties. So it's really important that you do meet an exception and that it's structured appropriately. Well, what happens is, a physician, you're not allowed to refer those Medicare patients for the designated health services. You also will have denials of payment, or you have to refund the money. But the biggest real penalty out there, and I think the biggest risk, is what we call False Claims Act cases. And so if you have a Stark Law violation, that can be used as a predicate act for a whistleblower to come forward and say, hey, I think this physician has a bad relationship with the hospital. So every single referral to that hospital, we believe, is a false claim. And that can be pretty hefty penalties, up to $17,000 almost per claim, triple penalties. And so the stakes are very big. You can also be excluded from the federal healthcare programs. So I guess the long story short, you want to make sure that you comply with Stark on the front end of relationships. So we can move to the next slide. And so there's a lot of definitions, but just think of a financial relationship as really broad. It's going to include anything that is a remuneration or any benefit that flows to the party. So it doesn't have to relate to the referrals, but it could be, for example, a lease of office space. That's considered a financial relationship. It could be your compensation that you receive from the hospital as an employee, or the compensation or the profits that you receive from your group practice. It could even be a gift. That maybe a radiology practice comes to visit your practice because that radiology practice wants your imaging orders. As a physician, if that radiologist gives you a gift, that's considered a financial relationship under the Stark Law. So think very broadly. It's almost anything you can think of. It's not staff privileges, but almost everything else. So we can go to the next slide. And so the scary thing about Stark is that there's no intent required. So you could have all the best intentions of the world, but maybe you have a lease of office space and you forgot to sign that lease agreement. So technically we have a violation of Stark, and the government doesn't care that you had the good intent. It's just a strict liability statute. So that's why it's really important to make sure that you have all your contracts reviewed. So let's move to the next slide. So these are what are considered designated health services, and this is when Stark is triggered. So remember, you're referring physician and you're referring designated health services. As you can see, that list is pretty long, but it really the usual suspects: clinical lab services, physical therapy, occupational therapy, the radiology services that I mentioned, home health services, outpatient prescription drugs. So we have Part B and Part D drugs. So if you're ordering medications for your patients, that's considered designated health service. The inpatient and outpatient hospital services, that's a big one. That means that, all your relationships, financial relationships with the hospital that you refer to, whether it's inpatient or outpatient services, that's going to trigger the Stark law. DME, the list of services that have the little asterisk next to them, the way that you can figure out whether they are designated health services or not is they're actually defined by your CPT and HCPCS codes. And that information is released every year in the final physician fee schedule. It's also listed on CMS has a Stark website. So if you Google CMS and Stark, they have a whole page dedicated to Stark, and they'll have a listing of the designated health services by category as well. So we can move on to the next slide.
Hey, Adrian, I wanted to just add a couple things on the previous slide, just to add to what Adrian was saying. I would tell physicians, in their practice, my Stark is going to apply to any Medicare patients, their fee-for-service patients that you are referring to your practice, for your practice to perform one of these services that falls in this category. Examples for any lab work, for any X-rays, if you have an MRI or CT machine in your office, if you want to dispense outpatient prescription drugs to a Medicare patient, Stark is triggered. And then I just wanted to add on the last category, inpatient and outpatient hospital services, pretty broad category. You may not have it through your practice, but if you refer any patient to a hospital and they bill for those services to the patient as an inpatient or outpatient hospital service, which is almost every service, then Stark law is going to apply to your financial relationships. So those are the keys to keep in mind. Voice is breaking again.
Clay, I think again your voice is kind of interrupting. I think it's going in and out, and I think there is something you need to correct. It's not clear at all. Can you move the speaker?
Okay.
So while Clay's getting that.
Go ahead, Adrian.
Okay.
Go ahead and keep going.
Okay, perfect. Yeah, this is better.
Yeah, that's right. But just to jump on that for a minute, in terms of Medicare patients, you're right that Stark technically applies to Medicare. I'll just say this from a compliance perspective, I like to treat it as Medicare and Medicaid. There are cases that have been brought, and it's depends on where you're located, that Medicaid can be swept into it too. It's also, when you're dealing with relationships, we're talking about Stark right now, and Clay's gonna talk about kickback in a little while. Kickback is also going to apply, and that's going to apply to all the federal payers. So I like to say, treat it the same, Medicare or Medicaid. When you start trying to change your relationships based on the payers, you can have some compliance issues. The other practical tip is, depending upon what state you're practicing in, many states have what are called mini Stark laws. That, for example, in Michigan, our Stark law basically takes the federal Stark law and applies it to all sorts of payments, so even cash-based payments. Every state is different. So from the front end, when you're structuring arrangements, so for example, if you're, negotiating a lease or maybe a medical director agreement, you should treat it as it applies to kind of all the payers and all your referrals. There's a difference if maybe an issue arises and you're trying to defend something and you can carve things out and make a great defense for yourself. But on the front end, I like to say, treat everything. Your relationships should really be the same regardless of what payer you're referring, the patient, where the patient gets their insurance. So we can move on to the next slide. And we can move just forward a couple slides. These are definitional slides, and basically it's just to show you everything in Stark has a definition, and there's also pages of commentary. We can stop here, and I'll talk about this one for a minute. I like to think of referring physicians. The referral is pretty broad, but think of like if you're ordering a service or ordering even a plan of care and it includes a designated health service, you'll be considered a referring physician. Now, if you refer something and then personally perform that service, that is not a referral. So, for example, if you're in a practice and you're a internal medicine physician, let's just say you order an X-ray. And then let's just say you read your own X-ray. If you do that, that referral of that professional component of the test is not considered a referral. Also, the 3 categories of physicians are listed on the slide. Pathologists, radiologists, and radiation oncologists are treated differently under the Stark Law. For the most part, you're not going to be considered referring physicians. And what does that mean? That means that these type of physicians might have other type of arrangements with hospitals or health systems or other designated health service providers that referring physicians cannot have. So different joint ventures, that maybe a radiologist could have a joint venture with the hospital and health system that a surgeon could not have because of the Stark Law prohibitions. And so it's just important to note, the Stark may apply in other aspects, but those physicians are treated a little differently. Unless you're an interventional radiologist, just note that interventional radiologists are often not going to meet this kind of exception. So interventionals usually are treated like referring physicians, so like a surgeon or other type of internal medicine physician, whatever the case may be. You can forward to the next slide, please. And then just a real quick note here. There's parts of the Stark Law that basically prevents circumvention schemes. So there are, cases and enforcement actions where maybe 2 different physicians decide, hey, I can't refer to this lab that I own. You can't refer to that lab that you own. So why don't I refer all my lab orders to your lab? You refer all mine to your lab. That's considered a circumvention scheme under the Stark Law, and will get you into trouble. It'll also raise significant kickback risks that Clay will talk about in a little bit. So we can move forward to the next slide. This is just another quick definitional slide. For our purposes today, just the definition of entity can be very confusing under Stark, but just think about it. It's, for the most part, it's going to be the entity that actually submits the claim. So a hospital that's going to bill for the inpatient or outpatient services. It could be a physician practice if you're billing for any ancillary services. So maybe you have a lab, maybe you have a pharmacy within the practice, maybe you do physical therapy. The actual group practice, that physician practice, will be considered an entity. And then a hospital in that case, or maybe a DME provider that submits the claim to the DME, all considered entities for purposes of Stark. So we can move on. Financial relationships are going to be really broad. Just a quick, it's going to be direct or indirect. It's going to be ownership. It's going to be compensation, all considered financial relationships under the law. And I guess from an indirect perspective, we're not going to get too much into it because that will take us down a real detailed path that's not necessary today. But just remember that you can't avoid Stark by, slipping, maybe start an LLC, kind of put another company involved and say, hey, I don't have a direct relationship. My company does. Well, Stark doesn't really allow that. Stark is going to kind of trace the different financial relationships. And so you can trigger it even if it's indirect. So we can move on to the next slide. Let's move on to the slide after that. And we can move on from this slide. And so,
Me at all?
I'm sorry?
How is my voice now?
Your voice is good now.
Cut now?
Yes.
Okay, keep going. I was going to add something to the indirect. I'm going to try and change my volume. Sorry, keep going.
Okay. Well, so we can move on to the next slide. I'll just say from an indirect, if you have an indirect compensation arrangement, this is getting a little bit lawyerly, but it just means that there's going to be a special exception and there's a little bit more flexibility than a direct relationship. So here's just a real simple slide about what, a simple Stark analysis. So a physician, let's say, orders an MRI and it's performed by the hospital. The physician is also paid by the hospital for certain administrative services. This is kind of the Stark analysis. The first thing is, do we have a physician? Did that physician make what we call a referral? Yes, the physician ordered the MRI, that's a referral. Now, does that physician have a financial relationship with the hospital? Yes, via that administrative services agreement. And so the question is going to be, can we meet an exception? And so we're going to now start talking a little bit about, luckily for all of us, we have a lot of exceptions into the Stark Law that really protect common arrangements. So we can move to the next slide. So really there's three types of Stark exceptions. The first we call global, but really when we say global, these type of exceptions really protect or really apply to the services that are provided. But what it does is it protects any ownership or compensation relationship. Then you have Stark exceptions that protect ownership. Now, there are not a lot of ownership exceptions. So for the most part, if you have an ownership of a designated health service, that unless you're in a rural area, there aren't a lot of options and you could have Stark issues. But there are a ton of compensation arrangements and exceptions that protect, like, employment, leases, all kinds of personal service arrangements. So we can move on to the next slide. So
Okay, I'm going to try and jump in real quick.
Yep.
Can you hear me now?
Yes.
I have not had sound. I apologize. I just want to add a couple things while Adrian's going through this. On the financial relationships, the concept that you can have an indirect financial relationship with like a hospital or an entity, it's a hard concept, but it's real. And I give an example of it. If let's say you have physicians who have ownership in a management company, LLC, and that management company has a management services agreement with a hospital, and the hospital pays the management company for management, compensation for those management services. Because the physician, either it's directly in the management company or through like an LLC that they own, they're going to have a indirect compensation arrangement with the hospital, and which is going to trigger the Stark Law for any Medicare referrals that physician does to the hospital. So that financial relationship, which is the payment of those management services fees to the management company that the doctor has an ownership in, that needs to meet a Stark Law exception. It's a little convoluted, but I think it's a good example of a situation where it's common that even with physician-owned hospitals, sometimes physicians have ownerships and ownership interest in other entities that provide services for their own hospital. So I just wanted to throw that out. Adrian's doing a great job going through this.
Sure. So we're going to turn to an exception that is pretty important. It's called the in-office ancillary services exception for either solo practices or group practices. This exception is really important because without this exception, group practices all over the country would not be able to refer within their own practices because the physicians have either maybe they're shareholders or they have employment relationships, right, with their groups. Well, how do you, the way the Stark is triggered, anytime you order, let's say that you're doing lab in your practice or physical therapy, if you're ordering within that group practice context, Stark is triggered, so you need an exception. And so the in-office ancillary services exception is the most popular exception that's going to protect owners of practices or practices that employ physicians. And so we can move on to the next, we can even skip to the next slide. And so, oh, sorry. I think this is a little bit different. Well, I'll talk about the in-office ancillary. I think they're a little out of order. It's okay. The in-office ancillary services exception really has, and we'll talk about value-based arrangements in a minute, but the in-office ancillary service exception has three basic requirements. The first thing is if you're a physician practice with more than one physician, you have to meet what's called a group practice definition. There are a lot of elements there, but I think for the basics for you to understand today, what the group practice definition does is it basically says, hey, you truly have to operate as like one unified group, kind of consolidated accounting, consolidated billing. You can't just get a bunch of physicians and kind of organize them as a way just to profit off of ancillary referrals. You have to truly operate as a unified group. Once you're a group practice, then you can take advantage of the in-office ancillary services exception, which really has kind of three main requirements. One is who provides the service. The second is where those services are provided, so a location requirement. The third is a billing requirement. Now, these are all pretty easy to meet. And so who provides the services? It could be the referring physician provides the service. It could be another physician in the group practice that provides the service, or the physicians are just supervising like an employee or somebody else in the group. So that's pretty easy to meet. Then it turns to, well, where are the services provided? And so there are many different location options in the Stark law, but there's really two main. You can either have a centralized.
So, Adrian, I wanted to ask you, are you on slide 30 with the picture of the building on it?
Yes.
There we go.
Okay, there we
Sorry, keep going.
Okay, so where can you provide these services? So there's either a same building or a centralized building location requirement. And so basically the same building requirements, there's like 3 different tests. They're really easy to meet. But really one of the easiest ways to meet it is like you're providing services in a location that has a single street address. And basically what it says is, hey, if you are a physician and you provide services, at least one of the tests, at least 6 hours a week, and that office is open at least 8 hours a week, and you provide services unrelated to the designated health services, so just your typical E&M services are provided at that site, you can meet the same building test. There's 3 different tests, but they're all easy to meet. And again, you only have to meet one of them. And the other option is, we can move to the next slide, is you can also take advantage of the centralized building location. And this means that you basically own part of the building, or you lease the building on a full-time, the location on a full-time basis, 24/7. Then that's easy to meet too. Oftentimes the location requirement is not really a barrier for most practices. And then we can move on.
So Adrian, let's give an example of that. I've seen a lot of questions in the Q&A about, can we do outpatient prescription drugs for our practice? Can we do DME such as CPAP machine? And the first comment I would make, other than those 2 questions, is centralized building. What that comes up with, if you have a building, your practice owns a building at another address, and let's say you want to send patients there for physical therapy services.
Mm-hmm.
You don't have to own the building, but you have to provide service, lease it on a 24/7 basis, as Adrian mentioned. Some people like to, can we go to a physical therapy gym and 3 days a week for our patients? So you could do that, but you won't be able to send your Medicare patients there. Or we're just talking about your Medicare patients. So that arrangement,
or if you're not
for commercial patients, or Medicare Advantage patients, which are not recognized today as within the gambit of the Stark law. And a lot of people, like Adrian, I agree with, to a certain extent, Medicaid patients, since they're subject to the Stark law. But I wanted to mention on DME, DME is, it's a designated health service, so it's subject to the Stark law, but it's expressly carved out of the in-office ancillary services exception. So that's not, you're a group practice, you go through your practice under one number, provider number, you won't be able to provide DME through your practice.
Yeah, like stop. Let me
now, of course, there's always an exception to that. I just beat her to it, huh? I'm kidding, Adrian, but if you're an orthopedist and you provide, there's a small exception, if you provide like crutches and wheelchairs and things to support your patients to make them ambulatory, you can provide those through the practice, but other things that are items that are considered DME and billed through the Medicare DME fee schedule.
Yeah,
so
and
provide that through your
Clay, this comes up a lot. I know we've talked about it a lot with practices. So there's one other little note here. Yes, for the most part, practices cannot do DME within their practice, right? Order it and bill for it. except for that carve out that Clay talked about, so crutches and things. But also the other issue is braces. So this comes up a lot, but braces are generally considered an orthotic. And so orthotics can be provided. So surgeons can provide orthotic braces, back braces, leg braces, knee braces within their practice, and that's okay under the Stark law, but just not your typical DME. And there's all kinds of nuances there, but for the most part, all other ancillary services can be provided using the in-office ancillary services, just not for the most part, the majority of DME. And CPAP, same thing. CPAP is part of DME. You cannot, and there's all kinds of specific rules about CPAP, but physician practices cannot use this exception to do the CPAP through their practices. So how the service is being billed, this is easy too. It's like, think about this, the group practice is just billing for the services through their, under a billing number assigned to the group, that's gonna meet the in-office ancillary services exception. There's also a couple other quick rules with in-office ancillary. If you're providing advanced imaging within the practice, you have special notice requirements, which are pretty easy to meet, but you got to notify your patients that there's alternatives, other practices that alternative locations that provide the same service. And there's requirements associated with that. And then for any physicians that may practice out of the home, so it's becoming more and more popular, physician services being provided in patient homes. There's still an opportunity to utilize this exception for those practices. And there's kind of carve outs to those location requirements. If you truly are a practice that sees the majority of the patients, at least 75% of the patients services are provided in the home, you can also do ancillary services in the home as well. So we can move on to the next slide. So real quick here, there's the way that the group practice and in-office ancillary services works is that it really allows physicians and group practices to split profits or divide their ancillary profits in a manner that complies with Stark. And there's all kinds of rules about that. But basically there's some new guidance that came out from CMS recently that said, hey, if you provide more than one service line, so let's say you provide MRI and lab in the office, you have to pool those two service lines together before you distribute the profits. You can't treat them differently within the group practice. So those are just a little nuances. If you are a group practice relying upon this exception, you really want to work with counsel to make sure that your ancillary profits are distributed in a manner and that all compensation paid to the group practice members is paid in a way that meets the Stark requirements. And it can become a little bit complicated, but we can move on to the next slide. So again, you're not going to have a lot of exceptions if you have an ownership in a designated health service entity and refer, unless you're maybe a rural provider, which is maybe few and far between in a lot of obviously urban areas. It's not going to work. Maybe places where Clay's from, you've got a lot of rural type of providers, which really allows a physician, for example, could own a separate lab maybe, or a separate, let's just say lab, and refer in like a rural area if really the lab is located in the area and the patients reside in that area. That's probably a bad example because labs take patients from all over, but again, limited exceptions really apply. So we can move on to the next. Compensation, at least, which is helpful. There's a lot of compensation exceptions. So there's one for space, equipment, and leases, personal service arrangements. There's even a fair market value exception, employment exception, payments to physicians at fair market value. That's a pretty popular one. So we can move on. All of these exceptions, we can move on to the next one. We can move on to the next slide. Yeah. So I'll just say this, for all of the exceptions, there's a lot of different, requirements in each one that we don't have days to go over them. But I think I like to tell my clients basic takeaways from most of the compensation exceptions. You should always be paying fair market value or receiving fair market value, right, for the item or service. So for example, a lease of space, the kind of the tenets are going to be, you have to have something in writing, signed by the parties. It has to be, detailed what you're leasing, But again, fair market value for the space that you're leasing, and also has to be commercially reasonable. And fair market value not related to the volume or value of referrals between the parties. So think about like it's two parties that don't have that referral relationship. What would you pay? There's specific definitions, but you got to pay fair market value. It has to be commercially reasonable, which is a separate concept. So a good example would be if you are a physician and you are leasing space, let's say from a hospital, and you don't really, or you don't really need the full, let's do the opposite. I'm sorry. So basically, if you're leasing space and with a referral source, and you really are paying fair market value for the square footage, and that is, everyone can agree that's fair market value, but you're leasing more than you actually need space because you're asked to do that. So that wouldn't be commercially reasonable. So you would have a Stark violation there. But I think really for most of the compensation exceptions, again, remember always that you're paid fair market value for the items or services, or that you are paying fair market value, that you have a writing. Most of the exceptions are going to require everything be set out in writing and signed by the parties, that you can never be paid based on the volume or value of referrals. So with all the exceptions, you want to make sure that before you enter into or sign something, that you do look at the specific exception to make sure, or you use counsel to make sure that you meet all the requirements. But again, those are going to be the basics there. So Clay, did you want to talk about anything on the fair market value, commercial reasonableness issue? Are we good?
Yeah, but it sounds like you want a break. Can you hear me now?
Yeah.
Good. That's a great way to let me know. It's a thumbs up. There's a lot of good questions going on, but I want to say with fair market value is it's a critical piece to trying to comply with the Stark Law or the anti-kickback statute, and you want your relationships where it's compensation or it's a lease relationship or anything like that to be based on an amount that's in a fair market value range. And to get that, you can't just assume because others lease space like that or others get paid like that it's fair market value. We generally recommend, or always take the word generally, I'll recommend that you either have your CPA or evaluation company that you get an informal or formal opinion that it's fair market value. And the importance of that is if you ever get scrutinized on one of your financial relationships, you can say, we had an independent valuation company or firm tell us this amount was fair market value. And that's what's going to support if you have to defend an arrangement. And just to mention on the slide that's on the screen right now, besides former President Reagan eating some Kentucky Fried Chicken, the importance of that slide when it says, a lot of the standards in the Stark Law talk about you can't be paid on the basis of the volume or value of the referrals, like more money because you're going to refer more. And it says, or the other business generated. The business generated is all your commercial pay, patients, everything else, not just Medicare. So your standard's going to be, you're getting paid a percentage of collections, or percentage of net collections is the amount paid for management services to your management company. You need to make sure that's based on a fair market value, that percentage collections always is triggered. It's going to go up or down based on your referrals. Even if it's a group of 20 physicians, your referrals will impact that. I don't want to go on that too long, but that's an important piece to keep.
Yeah, I think before we turn to kickback, and we will turn to that in 1 minute, just to say a basic comment, there was a slide on value-based arrangements that was a little bit earlier. I think it was like 26. And there are obviously, as we move from kind of fee for service to more value-based kind of payment arrangements with the different payers, the traditional Stark Law and kickback laws really weren't designed, right, for value-based arrangements. So what we see now is there's been some new exceptions under the Stark Law and new safe harbors that we'll talk about in a minute under kickback law that really apply to value-based arrangements. And there's many definitions and there's many exceptions. They're all compensation related exceptions. I think for what we need to kind of know today is that it's really going to be, if you are a physician, you may receive compensation under a value-based model. And it allows for the physicians to be paid in different ways, maybe something that's not fair market value if you meet all these rules. It's not the wild, wild west. You just can't enter into an arrangement and say, oh, what, now I can get paid for my referrals, or I can get paid over fair market value. You really have to meet the value-based arrangement rules, but they're really based on different categories depending upon the true financial risk associated with the arrangement. And so you have full financial risk, and then you have value-based arrangements that have some meaningful downside financial risk to the physicians, which means that the physicians are at least at risk for 10%. Or then you have a category called just value-based arrangements in general that really don't have any true financial risk. And then depending upon the level of risk associated with the value-based arrangement, there are going to be more requirements for the value-based arrangements with no financial risk. Full financial risk arrangements are going to be pretty flexible and not have a lot of requirements. So we can move to the next slide. Yeah, and so I think here it just goes through basically some of the requirements that if you do meet one of these exceptions, the typical Stark Law requirements that require compensation be fair market value, not based on the volume or value, and commercially reasonable don't apply. And so if you are in a value-based exception and it's satisfied as an employee, you can receive this compensation. That's no longer subject to fair market value. And we just say it with a little bit of caution. So you have to make sure that the whole arrangement is viewed in its entirety, that you meet all the definitions, all the exceptions, but it's something that we're going to see obviously more and more of as we shift from fee for service to value-based arrangements. And I think with that, Clay, we'll turn it over to talk about kickback.
Go ahead.
I think we should turn it over to talk about kickback now, and you go through some of those kind of the analysis of what we're looking for the kickback. And you can move over to slide, probably if you can advance the slides.
That sounds good. While the slides are being moved, I'll just add, if you are in a value-based arrangement, one of the most attractive things from the viewpoint of a physician is you are allowed to be paid based on your referrals. The opposite to the Stark Law and kickback statute. You're truly within that, because that's part of a value-based arrangement. They want referrals of a certain target patient group to be made to particular providers or services. So to incentivize physicians, it allows you to be paid for that. But like Adrian said, make sure it truly is a value-based arrangement, and someone's not just saying that so they think they can get around. Now let's talk, we're going to talk for about 15 minutes about some of the favorite things in the federal anti-kickback statute. And there's slides at the end of the presentation that compare the Stark Law to the anti-kickback statute. What's important right off to say is the Stark Law only applied to Medicare referrals. Now, the federal anti-kickback statute has both it's a criminal statute first, and there's also civil provisions to it, so you can have civil fines and not have to meet a criminal standard to have a particular intent. You still have to have, standard of a lower level intent to get civil fines. But the key is the federal anti-kickback statute applies to referrals or services to patients covered by any federal health care program. Medicare, Medicaid, TRICARE, federal employees. The only one that doesn't apply to is the last category, is the federal employees program, like people who work in courthouse, post office, etc. But it's very broad. And generally, if you are paid over, now I'm kind of cutting to the chase on a lot of this, but if you let's say you're paid as a medical director, you're paid over fair market value. The assumption, at least from the government's viewpoint, is then you're being paid for referrals because you're being paid more than fair market value. So that would be a kickback. And generally, with both these statutes, you keep in mind is that someone, a whistleblower, alleges that your arrangement violates the Stark law or you are violating the federal anti-kickback statute, then the claim that is submitted to the government, like the Medicare, the Medicaid program, as a result of that kickback arrangement, is a false claim. So it would violate the False Claims Act, and that's when they can really allege a lot of penalties because there's several severe. Basically, they take the amount of claims, double it, and then add fines and penalties on top of that. So just a fun thing to keep in mind, that could be your exposure. So on the federal anti-kickback statute, this slide talks about what is prohibited. What is prohibited by the federal anti-kickback
I'm not sure the
statute.
slides are being moved forward.
Oh, this is okay on this slide.
Okay.
I wish we could figure that out, but thank you. So the federal anti-kickback statute, the first thing is to violate it, you have the knowing and willful solicitation, receipt, or offer of payment. So either you could, as a physician, be requesting that you get paid more than fair market value, or you want some kind of financial remuneration to generate work for them, or you receive payment, and that's considered remuneration, and it's in return for either referring a federal program patient or inducing or purchasing or leasing arrangements. Next slide. The thing to keep in mind, remuneration could be anything of value. So it doesn't necessarily have to be cash. It could be something in kind. Maybe a hospital puts 3 employees in your practice. They give you 2 schedulers. I'm not saying that is strictly prohibited, but that's an example. You're getting something of value because otherwise you'd be paying for that employee and their benefits. You're getting something of value in your practice. It could be, a loan, or any kind of free items or services. There are the federal programs listed. So, who does it apply to? Very broad application. Remember, and this is on the next slide. The federal anti-kickback statute. Who's liable? If the allegation is an arrangement between a physician practice and a hospital violates the federal anti-kickback statute, both sides have liability under the statute. Not just the hospital, it can be the physicians as well. And in the last couple of years, the Department of Justice has been very aggressive in pursuing individuals, including physicians, for liability under these fraud statutes. So how do you analyze whether you have an anti-kickback issue? And this is the next slide. Similar to the Stark law, the anti-kickback statute has safe harbors. Safe harbors are both in the statute and adopted by regulation, and those are certain safe harbors, as you will, that have conditions that if you meet all the conditions of that safe harbor, then you would be deemed to be safe from the remuneration will be considered not to be illegal or improper under the federal anti-kickback statute. We'll go through that in a minute, but you generally want, whether you're an employee, there's an employment safe harbor to the federal anti-kickback statute, just like the Stark law exception. There's a services safe harbor. There's a safe harbor for lease arrangements. So your goal, like if you're joining a practice or you're at a practice now, you want, your list would be, you want to make sure your practice satisfies the in-office ancillary services exceptions for the Stark law liability. And on the anti-kickback side, structure your arrangements to meet a safe harbor with that. I know we're getting a lot of good questions, so it's tough to not, to resist these, but I'm going to throw out one practice right now because it's a question because it's practical. Someone asked if a practice is acquired by private equity, and the private equity owns all the shares, and is the in-office target exception still needed for in-office testing? Good question. I might bring Adrian in on that, but remember to meet the in-office exception, the practice has to be owned by 2 or more physicians. And actually, I'm sorry, Moy, I'm not sure if the physicians are no longer in the ownership of the arrangement, wouldn't be meeting the in-office exception, but I think you wouldn't be prohibited. You probably have an employment arrangement with your practice that you've now sold to the private equity company. So the START wouldn't apply. You need your financial relationship, whether it's employment or your contract for professional services, to meet one of the START law exceptions. You would no longer be meeting, looking to the group practice exception.
Yeah,
Does
so
that sound right, Adrian?
yeah. So with common like MSO arrangements where you have the kind of friendly PC management structure, you could, if it's of all the physician or the PE, structure like that, if they're all employed, you could just rely upon an employment exception. So there's ways to structure it. It's very common right now for the PE companies to invest in the practice.
There was a question about
And here's
serious
one-
pharmacy and the nurse practitioners being employed and then getting their prescription filled the same place. How does that not trigger AKS or STAR clause?
Yeah, please go ahead and answer this
Say that
question,
again.
but we have half an
Yeah.
hour dedicated to question and answer session.
Okay.
So my humble request to all the panelists and speakers is let us finish the presentations and we will address the questions, please. Thank you.
Okay, and if we just say this really quickly, the CVS scenario, it's like an employment relationship. So that's the compensation arrangements we talked about under Stark. If they're being paid fair market value and they can meet that, they're meeting the employment exception. That's how they're able to do that from the CVS pharmacy perspective.
Yeah, thank you. We have about 12 minutes for
Okay.
the presentations. And, with your kind help, we would like to extend the session for about 10 more minutes. So we have at least half an hour for the questions, because there are so many questions which are very important, for all the physicians that are participating here. And we will have an opportunity of, tapping your expertise through your answers, So we have another 12 minutes for the presentation. And then after that, I'll come back with the question and answers.
And I'm trying to reply to some of them in writing. So I got to some of them for you folks, but we'll certainly be able to address all of them when we get to the question and answer session.
Perfect. If you could go to slide 55, that's a good summary, a comparison of the anti-kickback statute and the Stark law. I'll go through that and then pass it to Mr. Denhofer. So this slide, the AKS stands for anti-kickback statute. This is a comparison of the Stark law and anti-kickback statute. Remember, both the anti-kickback statute prohibits paying or offering anything for a referral or receiving payment, and the Stark law prohibits the actual referral of just Medicare patients, and Medicaid is written in the statute as well, but CMS is currently not enforcing the Medicaid referrals. But if it's a Medicare fee-for-service patient, as they say, the red, white, and blue card carrying, not beneficiaries, not Medicare Advantage for one of the designated health services, and it says which the physician or immediate family member has a financial relationship. So remember, if your spouse has the physician also, and it's the referrals and kickback side from anyone, just a physician, the Stark law, the kickback statute, any items or services that are covered under federal program, and then the Stark is restricted to just designated health services. On to the next slide. And let's see, I'm going to go to slide 58, if you could.
Clay, if I could just make one comment on that slide, one big issue, one big difference from Stark to kickback, there's obviously several differences, but in Stark, once it's triggered, you have to meet an exception. With kickback, the safe harbors that are similar to exceptions are voluntary. So just because you don't meet every element of a safe harbor does not mean that you violated the kickback statute. Then you go through an analysis to see what are the facts and circumstances of the arrangement, and you look at all those factors. And so I think that's important to keep in mind, because many common arrangements will never meet a safe harbor, and that's perfectly okay.
That's a very big aspect. Thank you, Agent, for mentioning that. But people think you did not have to meet a safe harbor. It's voluntary, but you still want to structure your arrangement around that, but it's not mandatory. So just a quick comment. This is a case I thought illustrates some of the things we're talking about. There was a settlement of a whistleblower case in Oklahoma a couple of years ago. It's a physician-owned hospital by orthopedists and a management company in which several of the orthopedists had a ownership also in the management company. And the allegation was that the hospital paid improper remuneration or payments to an orthopedic physician group for patient referrals. And those payments were alleged to be and were listed on this slide and the next slide, 3 or below market value for office space and for employees and supplies, compensation in excess of fair market value for services, whether it's professional services or medical director services. And on slide 58, there were certain equity buyback provisions for certain positions that exceeded fair market value. I'd like to point that out because that's just one of the terms of the investment. If it's preferential and has certain provisions in it, that can create liability for you as well. So that's something to be careful of. Because of time, let's go to, I'm going to turn it over to Mr. Denhofer. He's been waiting very patiently, and he's got a lot of good things to share with us. And I see everybody's in agreement. I think we have a slide towards the end. With that, go ahead, Bob.
Yeah, thanks, Clay. So I'll discuss some malpractice considerations, and I suppose you can go to, I think it's the last slide, but regardless, here's, and since we have folks from different states on, and because some states have slightly different procedures, I'll kind of talk about generally what you should be considering. And the first thing is try to avoid malpractice claims. Now, of course, not committing malpractice is the first thing, but people can be mistaken anytime there's a bad result or a result that is unexpected. Someone could attempt to sue you. Your risk of that is minimized if you start up front with good communication. And I think that that's sometimes overlooked, especially with folks who have real technical minds. But good communication, setting expectations, and having good informed consents in writing are the upfront things you can do to minimize the risk that somebody has a result that they didn't expect and wants to blame you for it, whether you're responsible or not. And that happens all the time. So start with good communication. Now, if there is actually a claim threatened or a claim filed against you, the first thing you need to do is go to your malpractice insurer and report it to them. Now, here's where things can be different in different states. Some states, there is sort of an advance notice requirement where an affidavit from a physician needs to be provided to you so many days in advance of an actual lawsuit being filed, or some similar procedure. Sometimes the first notice you'll have is someone comes to your office and serves you with a lawsuit. That just depends on your state. And sometimes you might, and hopefully you never do, but sometimes a physician might just get some nasty letter or a nasty email talking about how the patient didn't like the result, or the patient thinks you committed malpractice. In any of those circumstances, the first thing you should do is go to your malpractice carrier and tell them about it in writing, and provide a copy of whatever you received. There are notice requirements for most malpractice insurance policies, and they will cover your defense and they'll cover damages up to a certain amount, but only if you notify them in a timely fashion. The second thing I'll tell you is you should go to a personal attorney. Now that won't be the attorney who the malpractice carrier selects to defend you or coordinates with you to select to defend you, who is a malpractice defense attorney, but you should have your personal attorney involved. There may be times where your malpractice carrier and you don't see eye to eye on something. They may want to settle a case when you don't want to settle the case, and there could be good reasons for that. They may deny coverage for some reason. It's less frequent in malpractice cases, but it can happen. You'll need your own attorney involved, at least knowing what's going on. So in case you need them, they can step in and assist. Now, when it comes to, I'm not going to get into the standards of what is and is not malpractice. Hopefully you're not in that scenario, but let's say you had a judgment against you or the potential to settle a case. You also need to be aware that even if the malpractice carrier is willing to pay for everything, you may have reporting obligations. You may have reporting obligations to your medical staff. If you have a settlement or an adverse judgment in a malpractice case, we'll need to report to the National Provider Data Bank. And you will likely, most states, you'll likely have to report it to your state board of medicine or, similar regulatory body. In all those cases, the way the report is written, what exactly is reported, and whether or not you actually have to report in this scenario are very important, and you'll want to consult with a personal attorney about that, in addition to the malpractice attorney who, although they're bound to defend you, they're also paid by the insurer, and usually paid by the insurer on a lot of cases. And so I advise having your own personal attorney at least know what's going on and looking at things. There may also be reporting requirements when you get a claim or in the event of an adverse claim, when it has to do with, to payers, IPAs, ACOs, other organizations that you're involved with of, kind of similar organizations. And again, we advise in addition to the malpractice attorney who will be hired by the insurance carrier and will do a lot of cases with that insurance carrier, that you also have your personal attorney involved in that process. I know I've kind of gone over a lot of stuff real quick because we're trying to get to the Q&A, but I think that's the biggest overview is good communication from the start, report any claim or any potential claim to your carrier and get your personal attorney involved, and be aware that while your carrier may pay for everything and they have an interest in not having you have a good result from the litigation. If litigation, their interests are not always 100% aligned with yours. So, just take everything they say with a grain of salt. So that's pretty much it.
Yeah, thank you, Mr. Dindofer. I take this opportunity to continue my recognition of the other two distinguished speakers. Ms. Adrienne Dresovic is a founding shareholder of the Health Law Partners PC, Farmington Hills, Michigan. She is a council member and vice chair officer for the ABA Health Law section and chair of the DOPS task force to examine the legal implications of the landmark Supreme Court decision. Ms. Dresovic also served ABA as a co-chair for the Physicians Legal Issues Conference, chair of the ABA Fraud and Abuse Toolkit, and ABA eSource publications, among other roles. Ms. Dresovic practices in all areas of healthcare law, and devotes a substantial portion of our practice to providing clients with counsel and analysis regarding STAR, fraud and abuse, compliance, reimbursement, and payer audits. Ms. Dresevic has written extensively on subjects across the spectrum of healthcare law. She is the recipient of the prestigious Burton Award for Distinguished Legal Writing. It is the Pulitzer Prize for Legal Writing. Thank you, Ms. Dresevic. And our third distinguished speaker is Mr. Robert J. Dindofer, a partner at the Health Law Partners PC, Farmington Hills, Michigan. He has practiced in almost all areas of healthcare law, but has focused his practice on regulatory and transactional matters related to healthcare practice arrangements, including captive practice arrangements, payer contracting, and managed care and audit compliance. Specializing in healthcare and insurance laws and related regulations, Mr. Dindofer advises clients regarding physician practice, hospital transactions, privacy and security matters, and arrangements with payers. In addition, he provides advice to clients regarding federal and state self-referral laws, federal and state anti-kickback laws, and information technology issues. He's an expert in government and public affairs law related to the healthcare industry. He has served as counsel for several healthcare and insurance trade organizations, successfully supporting legislative and regulatory initiatives. He has also worked in politics and government, successfully managing a United States House campaign in 2012 and helping to establish a congressional office in Washington, D.C. Thank you for joining us, Mr. Dindofer. So at this point, I'm going to open the question and answer session. And again, it's a great experience for all of us to interact with the national experts. However, it is sad that we don't have enough time. Actually, it is injustice to the program if we just want to condense everything in an hour and a half. My sincere appeal and request to the AAPI leadership is to have a dedicated 3-hour program exclusively for the malpractice session, and I'm sure you'll be considering it down the line. Now I'm opening up the session, as I said, for the question and answers. Here is one question. I own an office building that is rented by diabetes educators. They pay rent to me. I refer patients to them. Is that a problem? Also, continuing, there are no other diabetes educators in this area, and we have worked together for 13 years, and they went private just recently.
Well, let me say this. You can completely structure that in a lawful manner. You want to make sure that it's most likely going to be more of a kickback issue than a Stark issue. You just want to make sure that you are the fair market, the rent is fair market value, the space is what's needed. You have a signed writing between the parties. So that's a perfectly, you can be perfectly compliant in those type of relationships.
Okay. The next question is.
I agree with that.
Yeah, go ahead. Any other comments?
No, go ahead.
Well, I think,
it's only triggered if they're Medicare and Medicaid patients. So that's one thing to keep in mind. But
well, let's just say this. We have people from physicians from all different states, and a lot of states have their own mini Stark and kickback provisions. So I know Louisiana is kind of the wild, wild west play, but many states like New York, California, Michigan have lots of different, so you want to kind of structure those relationships. I always say from just a practice tip, act like, that those apply and you'll be compliant with every kind of.
If I may.
Which is a good point. I would add, we tend to let our professionals just be professionals, over-regulate them like in the state of Michigan. But besides that, most states do have a financial disclosure requirement that wouldn't be triggered in this instance, but I'll just mention that so we don't have to go back to it. If you're a physician and you refer a patient to another provider, at least like in Louisiana, you have at least a 5% or more ownership interest. You have to refer to them. You have to disclose to them that in writing. Generally, get them to sign that disclosure or our medical board would consider that, you know, a professional, what's the word I'm looking for, misconduct type issue. Go ahead, Dr. Mark.
If I may, I have a small question regarding different states. Are these laws kind of implemented across the country uniformly? Are there some location like coastal areas like New York, Florida, Texas, or Michigan, California? Are they more strict enforcement? What is the risk involved in these different locations?
And so
I would say for my purposes, it depends on the state. It's some states have more aggressive enforcement, just like you're saying, than others. Like we have a state anti-kickback statute that's enforced by our medical board. It affects your license, so it can't be a basis. It could be a basis for a fine by the medical board, but I would say the disclosure issue is more strictly enforced because that could be a misconduct issue. There's some states that have a state SARC law and things, and still make allegations. If you're violating that, they try to back into a federal claim that it violates a particular agreement, or you could try and get out of an agreement.
And it's not, I'll just say this is not uniform. Every state has its own nuances. Some of them, obviously, certain states are way more highly regulated, like the New Yorks and Californias. Texas is interesting, and some parts it's regulated, some parts not. They have major corporate practice medicine issues there, but kind of allow some things that aren't allowed in other states. Enforcement is very different in the different states. Again, some of the usual suspects like New York, pretty strict about things. There's different lawsuits. The AG will go after you. It could be a licensing issue. In most states, licensing laws are very broad to kind of capture all kinds of conduct, general, that could be considered as kind of misconduct, and different, repercussions depending upon the state. So you just always have to be careful when you're structuring things.
Thank you. I'm combining two questions into one. I think this is regarding the rental of the equipment that you own to your own patients, So the question is, if there is any equipment like CPAP that you own in your practice, can you rent it to your patients and then bill? The second thing, then extension of this question is, if you own the X-ray machine in the office, can you take X-rays and bill Medicare?
So I'll do the X-ray question. Yes. So that exception that I went over, that in-office ancillary services exception, is the one that really allows that X-ray in the office. It's very, very common, easy to meet that exception. If you have a radiologist, though, outside of the group that's reading, you have to be careful about that arrangement. So is that radiologist off-site? There's Medicare anti-markup rules that apply, and also the Stark law. So just make sure that that radiology arrangement reviewed carefully. And a lot of practice,
which is also impacted by if you're billing for the radiologist or not. Who does a professional research? If they separately bill for that, then you'll have less.
Correct. And then the CPAP question, I'm pretty sure that CPAP right now is, and I'll defer to Clay if you know this, I think CPAP is DME, and I don't think you can provide that in the office unless you're, maybe if you're in a rural area, you could kind of do it under maybe the rural provider exception, but for urban, I'm not even sure, but I think, and there's also a lot of rules with CPAP and Medicare.
And I typed an answer to that one. The CPAP machine is considered DME. And so for Medicare patients, you won't be able to refer them and provide it through your practice, whether you're renting the machine or how you're providing it. But for your commercial patients, you can do it all day long.
Yeah, it depends on the state. So you can't do it in Michigan, for example, but maybe in a lot of other states you could.
Thank you. In a group practice, is income from anesthesia, pathology, and research treated as DHS?
So so not research, the pathologist, so those lab services would be considered your DHS, and then you pool them together, and you just have to allocate that in a way that complies with the STARK. So you can't, so basically there's a lot of details in those rules, but you can't pay the physicians based directly on their orders. So, but you can find other methodologies for paying them. So you
Thank you.
for example.
Yeah, and I'll just add for anesthesia, it's a professional service. Professional services are not subject to the Stark law as within one of the designated health service categories. But I'm also wondering how much anesthesia, I mean, for certain in-office procedures, you're probably doing local and stuff with anesthesia, but.
Thank you. Can husband and,
That's right, Bob.
yeah, sorry.
Go ahead.
Can husband and wife with different LLC practices, different LLCs can practice under the same roof and refer to each other? This is
So,
very common, wife and husband practicing under the same roof under different LLCs, so I think.
Well,
this is
in my
very
world, I'm gonna find a way to let that, Adrian will probably shut that down, but anyways, go ahead, Adrian.
be the bearer of a little bad news. So, and there's a special exception if you're in a rural area for under Stark that allows intra-family referrals. It's kind of narrow. However, if there's DHS, so again, if there's no DHS, you don't have to worry about Stark. So those designated health services that we listed, but if there are referrals of those designated health services, technically it doesn't comply with Stark from a Medicare federal perspective, and then you'd have to look at your state law. And I know it's common, and probably I will say this, there's not been a lot of Stark enforcement where we see all the activity. I know there were some questions on this, has really come from the whistleblowers out there. So that's where you have to be careful of, is like competitors to find out. That's where things come out. Someone just asked what DHS is. There's a slide in there, but designated health services are the lab, the DME, the physical therapy, occupational therapy, orthotics, the hospital service, pharmacy, for example, just to name a few.
Thank you.
And I'll just add quickly, as you can imagine, almost everyone is Louisiana is related. So except for me, I'm actually a native of Chicago. So, but I've been down here a while. So
Same in West Virginia too.
It's a lot of times I find that people will, instead of just the referral, maybe they're going to have an arrangement where they're billing for their spouse's services. They're doing some kind of professional service arrangement on those particular services. So you're not all caught up with, no, my sweetheart, I can't send you any patients, and they don't like that. But
Thank you. Can we break a lease contract due to financial hardship?
So that's a contractual issue. And you can maybe come up with some settlement, and then potentially if it's a Stark issue or not will depend on the relationship of the parties, but there's a way to kind of settle financial disputes, I think, and comply with Stark. Correct. Yeah, I think that's all I have.
Thank you.
Yeah.
This is a very
the way you get back into that is if you have financial hardship and you stop paying rent, but you still use the space, then you could have issues. Stark law and get back there.
Yes. Thank you. This is an interesting question. If a practice is acquired by private equity and the PE owns all the shares, then is in-office Stark exception still needed for in-office testing?
If none of the physicians own the practice, then you could rely upon an employment exception for those physicians. So you wouldn't technically probably need that unless you have a physician that owns and refers in that practice. That's the only reason you'd need it.
What are the consequences of breaching a lease contract, renting space from health system?
The consequences would be, it depends what they mean by breaking the lease. If you just move out and don't pay your payments, it's out of the terms of the lease that they'll try and collect the rental payment or terminate that. For terms of our presentation, if you break the lease, you don't want to continue to use the space or any additional space. And I just want to do one add-on. If you are leasing space from a hospital or a health system, and you increase the amount of space that you use or decrease it, make sure your lease is amended so it matches the space you are using, and you're paying rent based on the amount you are using. Because those issues come up a lot where over the years, a practice may grow and add additional space, additional floors, but it doesn't get added to a lease. then you're going to have a compliance officer from the hospital knock on your door and say, we need another $150,000 by the end of the week. Otherwise, we're going to have to self-report our situation to the federal government, which is not essentially true.
The other quick thing about that, Clay, the other quick note is that remember, like the hospitals council, if you break that lease, they may use Stark and kickback as kind of a weapon, right? To say, hey, you owe us all this money under the lease contract, and if we don't collect that from you, we have a Stark violation kickback issue. And so then you have to
Which is true.
Which is true. And so then you have to get involved in, you hire an attorney, get involved in good negotiations to come up with a reasonable, fair settlement and come up with your factors to try to kind of comply with those regulations.
Yeah, thank you.
Should I call these add on, Dr. Murphy?
Okay, moving ahead. This question has been asked, and I guess it was also partially answered. If a physician wishes to dispense a drug that is also available in the local pharmacy, does the physician need to obtain a license from the Board of Pharmacy to dispense?
So it's a state by state issue, but most have a specific dispensing license by location, I believe. And then you can do it under Stark. And then, but there are going to be pharmacy, like local state rules on what you need to do to be able to dispense in the different licenses you need.
Thank you.
Yeah, I would say, with this question, it is a state by state issue. I've seen several states, you don't need to go to the Board of Pharmacy if you're going to provide prescriptions or outpatient drugs for take home through your practice. You may need to register with your medical board that you're a dispensing physician. And with Medicare, it's very hard to meet the in-office exception to be able to dispense prescriptions. So there's a lot of vendors to try and sell those arrangements.
Interesting. The next questioner obviously has some stocks in imaging facility. So his question is, if we refer the patients to imaging facility for MRI, but patient has Blue Cross Blue Shield, non-Medicare, Medicaid patient, will it violate the Stark law?
So technically from a federal Stark law, again, it's like the strict Medicare. It depends on your state. If there's been a case, if it's a Medicaid patient, the other payers, it's going to depend on those payer policies and also whether your state, like Michigan, you couldn't do it in Michigan because of our state Stark law, and that would be a licensing action.
It also depends when they say Blue Cross Blue Shield, whether it's a private plan or a Medicare Advantage plan, because a Medicare Advantage plan, even though it's issued through a private insurer, counts as a federal healthcare payer, Medicare payer.
But not for Stark, so it would be more of a kickback analysis than,
The questions get more and more interesting. This is obviously regarding the workman's comp.
Okay.
Does any of the laws apply to physician dispensing medication from the office to workman's comp patients?
Well, so it's a state law, and then also, and maybe Bob, you might know some of this too, there's different arrangements from workers' comp, it's different in every state. There are arrangements that allow, in some places you can dispense for workers' comp patients. You have to be careful. A lot of times I think consultants will come up with a program, right, to the physicians, and you want to have those looked at because you could have some issues under the state law, or it could be under, have an issue from, depending upon where you're located, but
Thank you.
I'll just say, the short answer is the Stark law and the federal anti-kickback statute do not apply to workers' compensation patients.
What about the dispensing of
the federal workers' comp? Go ahead, Dr. Murthy.
Sorry. The physician, can a physician dispense weight loss drugs directly to his or her own patients?
Yeah, I mean,
they can. Just keep in mind what type of patients they are and what they're covered under. If it's a Medicare patient, they still need, and if they're considered an outpatient drug, which it would be, they still need to meet Stark laws. So other than that, they can, if it's a commercially insured patient or a cash paying patient, they can dispense those drugs. just need to comply with any state requirements for physician to be able to dispense.
It's
drugs
really
through the
common.
environment.
It's really common. You just want to make sure that you understand the laws of your state to make sure that you're doing it appropriately. Mhm.
If I may add here, similar question, can I sell natural supplements to patients from another company owned by me?
So generally speaking, I'll say that I've looked at this in a few states. You can, I would say for the most part, it's okay. You'd want to look at your state licensing laws to see if there's any like transparency or disclosure requirements. But it's really common, right? You have that type of arrangement. You just want to see if your licensing board has a problem with it or not.
Yeah, and the same here. I've worked with a lot of practices that do sell the supplements. The biggest issues come up on what are the supplements and are there any FDA issues with those actual supplements. So it's a little bit outside of the fraud area, but you still want to know what product you are endorsing and selling to your patients.
Thank you.
Liability.
The next question, I'm deleting for the sake of privacy, the state where this is being done. The question is, nowadays, in this particular state, one marketing group charges $100 to $150 per patient referral.
No. go
These
do it.
patients are referred from jail. Is it legal or illegal? I rejected this group and I have no connection. Does it sound fishy?
It does sound fishy. I would
Yeah.
say
Sounds like they answered that. And again, this must clearly is in the state of Michigan type of arrangement. But anything where you get a payment that's triggered on a per patient basis, it's a high risk, high probability of creating liability or getting you in trouble
yeah.
under for sure the federal anti-kickback statute, and it's almost regardless of the type of patient. So,
Yeah, thank you. Thank you. I got a confession, I practiced and retired from the active practicing of the law. Now I'm an academic physician. I practiced for almost 32 years. I never felt that I am more of a legal guy than a physician in this day and age. I think, it is very important, that's why I always suggest whenever I go to the national meetings, our younger generation is not exposed to this kind of information. There are very, very few international medical schools, that mandate the legalized medicine as a part of their curriculum. And I've seen many a friend, just signing the contract, coming out of the residency and all that medical school and all that, without looking into it. Well, as you know, the organized medicine in 1960s and 70s is a different kind of, totally different, as you know. Now, the physicians are subject to so many restrictions. Well, sometimes I wonder, how much of time we need to spend for the patient care, and that is definitely a compromise. And that definitely is one of the major factors for the stress of the physicians, this is just my 2 cents, it is so sad to see that the physicians who work hard to become physicians and practice, sacrificing their family time and all that time, has to undergo the tormentation of the regulations and all that, which are really, in general, not very physician friendly.
No.
So go ahead. So if a physician is an employee of a hospital and is being salaried at higher than fair market value because of rural setting of the hospital, does it come as an exception?
Well, I'll just say this. You always have to be within the range of fair market value. Part of that question I think some of the facts in that question, as a lawyer, I'll just say, because it's in a rural area, the fair market value they may have an opinion that is actually fair market value because you need that physician. So you have to be paid fair market value. What fair market value is a range. Healthcare attorneys can't tell you what that range is, but there are factors that go into it, and there's specialists that look at that. And there are certain factors that will drive higher compensation for certain physicians, and that could be one of them. I guess I'll leave it at that.
Yeah, and that's essentially it. You always want to be in the fair market value range, but like Adrian's saying, evaluator, because it's in a rural area and the need for that particular specialty there's reasons where those are reasons generally evaluator can justify a higher amount of compensation, but they're still going to say it's within a fair market value range for that area.
And if they didn't say that, then yeah, you could be potentially a whistleblower. Sorry. I don't like whistleblowers, but.
Yeah,
There may be one more question and we'll stop it. I think we are at 12:40.
thank you.
If you can take one more question, then we'll stop.
Okay, I think, I'm sorry, now I'm playing the bad guy, of not asking the rest of the questions I do.
Can I read a question
truly
here that's on
apologize.
the screen? Our group has been removed from the hospital ER call, but still has the privileges. They have required an independent ER group to refer a patient to a hospital employed physician. Is this any type of kickback, anti-kickback, anti-competitive issue?
I could write a letter arguing that. With those type of arrangements, when there's a, ending of a contract and another group comes, there's certainly potential arguments there, but it depends on obviously every scenario.
Thank you.
I agree with that.
I think now the final remarks. Dr. Ravi Kohli,
No,
Dr. Srini
Bob, do you
Gangasamy.
have-
yeah,
Go
I
ahead.
mean, there are so many good questions and so many well answered and some unanswered, unanswerable questions as well. And it's always a kind of we have a different paradigm shift when we come to talk to lawyers versus see the patients in the office. So we have to think differently. Sometimes it becomes a little bit of a blinds us to where does our loyalties lie, the patient care or just following the rules, and sometimes they may not align. And I also have one question. When we have a malpractice attorney as well as your own personal attorney helping you, what did the ethics say? Does the malpractice attorney hired by the company only have the loyalty to the company or to the truth and the justice? I mean, that's my ethical question. But beyond that, it's an interesting question, interesting discussion, and really appreciate Dr. Vemuri and Dr. Gangasani for arranging for this long-awaited topic and discussion. And thank you very much. And
Sorry.
let
me give like a 1 minute, and then I'll give it to you to recognize. Because thank you,
Sure.
Adrian, Clay, and Bob for doing a wonderful job. I think it's an eye-opening session. I know for the lot of the members, I think we got a lot of new information. I think we cannot answer all the questions in this session, but I think after listening to what Adrian, Clay, and Bob said, I think if you're in doubt, I think ignorance is no defense. I think we should just have a contract, talk to one of the attorneys group so that what we are doing is correct or not. I think a lot of us, we assume that we're doing the right thing without going through the legal kind of way of doing it. I think I know I learned a lot of it between what Adrian said about the anti-kickback and the STARK law. I think we have a simple understanding before, but I think this kind of eye-opener for a lot of things we do, little things we do. I think if all the members, whoever have the questions, I think you can get a local group, or if I think I know they gave the contact, and I think Adrian had the contact information. You can contact them, or if local state, because the rules are different in each state. That'll be wonderful. But a really eye-opener session for all of us. Thank you, all the speakers, for doing a wonderful job, and Dr. Murthy for exceptional job as a moderator. Then I would like request Dr. Ravi Kohli, the president, to recognize the speakers. And I'll ask all of you to send some address to me so that we can send the plaques to you in the mail. Go ahead.
Yeah, go ahead. The office, can you display the plaques for us to show it to the members as well as? Okay, here is the plaque number 1 to Attorney Clay Countryman, Esquire, for your outstanding contribution to the medical legal physician questions. Welcome to the AAPI Distinguished Speakers Club, assigned by Dr. Ravi Kohli and Srini Gangasani, the CME chair, March 18, 2023. Thank you again, attorney. And the next one to be recognized, Attorney Adrian Dreschevic, for your outstanding contribution to the physician and medical legal arena. Welcome to the club as AAPI Distinguished Speaker. Thank you, and Ravi Kohli and Dr. Srini Gangasani. Next one, Mr. Attorney Robert Dindorfer. And again, thank you for your outstanding contribution to the field of physician and medical legal services, signed by Dr. Ravi Kohli and Dr. Srini Gangasani. We'll be receiving these plaques in the mail. And again, thank you for joining the distinguished panel.
Thank you for having us.
Thank you.
Appreciate it.
Thank you for having us. We appreciate it.
God bless.
Thank you.
Good day. Bye.
Thank you.